All right. Any other setovers, strikes?
Number 18, Judge Rogers and Burton. Mr. Levitt's involved in that. We discussed this morning some agreed changes, which I have signed off on and interlineated. Those will be coming over ex parte probably this afternoon. With that, I think you can strike the presentation hearing.
All right. So I have a bunch of orders that were, looks like came from your office. Should I just set those aside then?
Yes, just set those aside, and we've got cleaned up ones that will be headed over here probably this afternoon. And I don't think anybody's been affidavitted, but I'll put those in your box so that you can review those, but they're agreed.
Okay. Do we need any other dates or any information from Ms. Powers? Looks like you're on this case as well.
I am. I did sign off on the temporary child support order. If the parties changed that one, please send it over to me. I haven't seen a changed one since I signed off.
All right. So we'll strike.
This is the Rogers Burton matter.
Yes.
And really quick, Mr. Burton has indicated that he will be proceeding without an attorney. Moving forward, I'll need to put in my notice of intent to withdraw. I understand that he may have wanted to address the court briefly. I've told him that we're limited to what's already been decided. But he did send me a text that he was interested in addressing the court regarding accommodations for the supervised visit. Mr. Burton, are you there? And do you want to say anything?
Yeah.
You can take your hat off, sir.
Okay.
Thank you.
May I speak?
I'll give you a few minutes. Yes.
Thank you. So yeah, regarding the supervised visits, I had my first one. We are still waiting on Asher to take his intake into that. As far as the reconnecting facility in Longview, it is pretty much booked up from Friday to Sunday, and I'm unable to take time off of work due to I would be fired from that. So if I do cut the overtime, I wouldn't be allowed to work the overtime. And so if I do take time off of work, so then I was wondering if we're able to do a different facility by chance that has more availability as far as hours go. And then one more thing was previously you mentioned up to 3 hours a week, but in the order I saw that it was only 2 hours written down. And so personally, I would like as much time as I could.
I believe that's been changed by agreement. Is that correct, Mr. Zandy?
Correct.
Okay.
So at this point, as soon as Mr. Levitt is no longer your attorney, you're going to be free to discuss things with Mr. Zandy. I'm not changing my ruling at this point. I think supervised visitation is appropriate. If Ms. Rogers is willing to consider a different location, I have no problem with that.
Okay.
I understand that there's a significant gap in locations as far as where you reside and where she resides. I think the onus should be on you, given the current situation. But if she's willing to look at Woodland, Vancouver, or somewhere else that may have options, I'm not going to prohibit that. So maybe either Mr. Levitt, while he's still your counsel of record, or once he is no longer your counsel of record, you can contact Mr. Zandy and see if that's something that they would consider moving forward.
Thank you, Your Honor.
All right. So otherwise, I guess we'll set this. I'm not going to set any further dates, and
Yes,
I will sign off on those orders once I receive them.
And we're on for a multitude of motions today. Now, the first is to serve Ms. Parra via mail. We have done that. We've already got the order signed. I believe it was by either Your Honor or Judge Hahn some time ago. That came back returned. Now we're also on for temporary orders, reissuance of the restraining order at adequate cause. As I told the court last week, good news. Gael is back from Mexico. He's been returned with help from the FBI. So he's with Dad. He's back in school. Things have been going very smoothly and very well. At this point, it's about simply locking in an order that prevents Ms. Parra from doing exactly what she did last fall, which is take the child and run. So we are asking for you to reissue the restraining order as well as the temporary order as we have suggested, and the adequate cause so that we can get a parenting plan in accordance with that restraining order that limits any contact between Ms. Parra and the child or my client who remain in Longview.
All right. One thing, there was a note in Odyssey from May 23rd that the court will sign, and that was when Commissioner Nelson was covering for me. Court will sign a restraining order upon presentation, and Mr. Zandy to provide ex parte. Has that happened yet? Or
We did not do that. I instructed staff just to withhold until we could get all the orders in front of you, just to make sure those were all entered simultaneously for convenience.
all right. I've reviewed everything that you filed. I'm pretty well aware of the circumstances surrounding this case and the difficulties that have been had trying to get the child back. So I will, I'm going to grant every request that you've made thus far. So I'll sign all
Thank
of
you.
those upon presentation. There was
Thank you.
confirmation of service in this case. Is that correct?
I think we mailed that to Mr. Wolf and also by email. Let me double check. I have a certificate of service that was mailed to his PO box, signed May 9th.
All right. So this is an interesting one. So there was initial petition and summons from October 2022, and then basically it was stagnant for about 6 months. And then the restraining order and new service was filed. I have not received any response. Have you received any response?
No, we haven't. I'm not sure if Mr. Wolf is even going to appear today. So maybe we should check to see if he's here.
Is there a Ben Wolf present? *6 to unmute if you're on a telephone. Ben Wolf. All right. Did you submit any proposed orders?
No, I'm not in the habit of doing that. So
Okay.
I'll have to come back, I guess.
Let's see here. So I will, I'll grant the restraining order regarding the business and property. And he's already out of the home. Is that am I recalling correctly?
He's had to come back and get some items, but with some written or some kind of notice, she doesn't mind that.
Okay. So the restraining order as far as the business and property I think is appropriate. So I'd authorize that. There is a significant amount of maintenance that's being requested, but it appeared to me that she would also be taking over essentially the maintenance and payments of the mortgage on the primary home as part of that. Is that correct?
Yes. So she's going to pay some credit cards, her vehicle, and the mortgage. She's going to pay part of her auto insurance as well. So the main thing, I guess, what we're asking for is just kind of access to the business record. We have discovery that's outstanding, so that may this being addressed through discovery, but we'd like to have in the temporary family law order that access to the business platforms or business accounts be provided on a monthly basis.
All right. And I reviewed that motion for temporary family law order. And at this point, given the financial declarations that have been filed, I'll approve the request, including the maintenance amount, with her taking over the credit cards as listed, as well as the mortgage, utilities, homeowners insurance, property taxes, and the vehicle, and that she's using in the HOA fee for the home. And
we're asking for a contribution from the respondent for a business valuation that we're doing through Perkins Co. She's paid $1,300 for the valuation, and there's $2,500 left to get that started.
So is it a total of $3,700 or $3,800, excuse me, for that service?
Yes, that's right.
Okay, so you're asking for the remaining $2,500 to be paid by him?
Right.
Yes, I'll grant that as well. And the attorney's fees is requested.
Okay.
All right, we'll set it to the 13th for presentation at 1 p.m.
8308.
Thank
We're
you.
on for
All right, thank
several
you.
issues. The first is guardian ad litem review. Just to talk about where we are in that process, the reviewing the motion to compel, and then there was two orders from a motion or two pieces of a motion for relief that the court had set over to address essentially today. We do have the guardian ad litem present, as well as the opposing party are present today. And for the record, I'm Chelsea Baldwin. I'd like to address the guardian ad litem review first. So where we were originally was sort of at the end of 2022, there was a custody change to my client due to violations of the court's order preventing the respondent's boyfriend from having contact with the children. From there, the court sort of, because that was not very expected, the court granted the guardian ad litem extra time to suss out how long that contact had been happening. And that's where we have sort of that motion to compel issue regarding the phone records. And so that's, we've been a little bit in a holding pattern waiting for those phone records. We did finally get those in about week to 2 weeks ago, which as the court now knows, revealed a substantial amount of continuing and ongoing contact that was directly contrary to what the respondent claimed was going on, and directly contrary to the documents she produced. For the purposes of the guardian ad litem, unfortunately, within the last week, one of the children made a disclosure that has resulted in a criminal investigation and a planned CJAC interview. And that's regarding, again, contact between the child and the boyfriend. So at this point, I think the guardian ad litem, because that's newly emerging, I think the guardian ad litem should have a little bit of additional time. I understand criminal investigations can go on for a while. I would suggest 30 to 45 additional days, let the CJAC interview play out so that can be included. And so I was thinking sort of mid-July for the guardian ad litem to be able to issue a report, not only on the phone records issue, but at this point, all safety issues and any appropriate issue, the guardian ad litem should just be free, hands untied to address those to the court. I will reassure the court that the child's needs are being met. Specialized counseling is being, we're obtaining referrals, CPS referrals, and all the appropriate care that the child will need to address the situation. And we do have the guardian ad litem present.
That's Ms. Gravina, correct?
Yes.
Okay, thank you.
This is Tanea Gravina, the guardian ad litem.
Good afternoon.
And yes, this previous weekend, Your Honor, father disclosed to me that the child is making disclosures and there has been involvement with law enforcement, CPS, and father is awaiting a scheduled CJAC interview for the child and a referral from the pediatrician for a pediatric sexual assault therapist. And I simply only have that extent of information to give the court at this time. I have reviewed the phone records as well as the documents mother provided. And as far as that piece of it, have a firmer understanding, but with new safety issues, I do have concerns, Your Honor.
Does the time frame suggested by Miss, excuse me, by Miss Baldwin, well, knowing that we don't have any control over the if and when any criminal charges may arise from this or how that is even handled, is a mid-July date reasonable?
I would anticipate potentially receiving the results of a CJAC interview by then, but I am doubtful of receiving any CPS or criminal information by then, Your Honor. So if the court would be okay with me presenting the phone record information and the CJAC information only at that time as an update, that would be appropriate, Your Honor.
And I don't have any issue with pushing out further into August to give more time, sort of whatever the guardian ad litem thinks she needs.
Your Honor, if I may.
Sure.
Okay. So we are here today to review the GAL report. This was originally set back in the beginning of February, Your Honor. During that hearing, Ms. Baldwin had indicated that she had information, including a potential video, which was the whole basis for her extension request for the GAL to finish this report. My last understanding from when I spoke to the GAL a few weeks ago regarding this is she just now received the phone records from Ms. Baldwin's office. And to my knowledge, she's never received any potential video alleged evidence, which is the whole reason why the hearing got pushed out in the first place. So I do agree that the GAL should do an updated report. But I believe that, or I'm asking that the court allow her to do a full updated report, not just on my end. The girls have been living with their dad for the past 6 months. So it's been a big change for everybody. And so I think that anything that either side wants to bring up, if we need to pay additional fees for the guardian ad litem, I understand and am, prepared to pay my half of that. But it's been a good amount of time since the children have been in petitioner's care. So I believe a whole updated report would be needed. Up until my understanding last week, Ms. Baldwin didn't provide anything to the GAL for the last 3 months. I got what was needed to the GAL when she requested it for me back in February. And I've done what was asked of me. You can see in the GAL's report that back in November, the girls went to go live with petitioner and that the court had me do a class. I immediately went and took the class. I did 2 other classes on top of that. The GAL also requested that I do therapy, which I was already in therapy just in relation to this whole process. And that all of this was just a temporary relocation for the kids' safety We come to the hearing in February and, oh, it needs to get pushed out because there's all of this new evidence, which Ms. Gravina can touch on this if she's received it or not. But the whole basis was because of this alleged video, which to my knowledge, the GAL hasn't seen it. I have not seen it. I couldn't make a motion pending that allegation because the court granted more investigation time. I was prepared at that time in February, if the court accepted the GAL's report, to do that so I could get some residential time back with my kids. I'm not objecting that she needs to do an investigation, but that she should get to do one on both parties, not just myself, because the girls have been living there, like I said, for quite some time. I've sat patiently. I've done what was requested of me. I've done what the courts have asked me to do. And now all of a sudden on Friday, I find out Friday afternoon before this hearing, again, this huge allegation of something going on, which I agree that it needs to be investigated, but it just feels like a pattern that this happened in February. It's happening again now, and everything is just getting pushed and pushed and pushed. So Ms. Baldwin, as I said, indicated that there was some video evidence, I believe was the wording that she used, that I'm not sure any party has seen. And now there's this very serious allegation that's going on, which the first I've heard about it was Friday afternoon. And again, I understand that there's a procedure for that and that some things need to happen. And I wanted to get to the bottom of that also. But everything keeps getting pushed. I don't know if I'm allowed to still have my supervised visits with my children. I haven't seen or talked to them since last week. So I don't know what we're doing, but I've done everything that the court has asked me to do and then some. And every time it feels like I get close to the finish line, something else comes up that's brand new information that pushes everything out and keeps me from spending time with my children.
Well, I understand your frustration, and I I would be dishonest to you if I sat here and said that it isn't frustrating to the court as well. But the GALs are appointed in these cases. They get information from 20 different angles. Some of that stuff takes a really significant amount of time to get back with different, ROIs and different requests. So I understand your frustration. I get frustrated as well when we set a final GAL report date and then there more time's needed. That being said, I also understand the GAL's point of view when more information trickles in, sometimes more serious information, and some information isn't received. So, or maybe received in a timely manner. But it sounds to me like everybody wants the GAL to do finish the report, look into all these issues. And I will say, Ms. Gibson, the GAL is looking at what's in the best interest of the children. They're not investigating one parent. They are looking at the entire situation and for any safety issues and concerns that they may have as an outsider looking in for the children in the case. So it wouldn't be just a witch hunt for you or a witch hunt for Mr. Gibson. It's basically looking at everything that is provided to them and giving a summary to the court. So everybody, it sounds like, wants the GAL to get that completed report and have as much information in it as possible. So Ms. Gravina, what if we were to do a report? How about July 25th?
Your Honor, if I may, I am hesitant to include any interviews with the children prior to CJAC interviewing the children. I would not feel like that was within my scope or expertise. If there were any disclosures or any other statements made by the child, and don't want the court to be misled thinking that I could wrap something up sooner than that. If I am having to plan a trip up to, I believe, Spanaway and do so after CJAC and still be able to provide information to the court that soon.
All right. Well, when do you think, can you give me a date then?
I could meet with the children probably shortly thereafter. I'm assuming mid-July. So maybe beginning of August, if the court would like updated information about Father's Home and the children's adjustment to that, as well as the additional information that's already requested by the court.
I propose August 8th. I have an appointment on the 1st that might make me unavailable at the 1 o'clock docket. So I would propose August 8th then. If there's major issues that happen before, then we could always note it back on and address those with the court.
Yeah, I would prefer a realistic date, and even if that's a little further out than having a shorter review and then only to not have any resolution at that time. So, does August 8th work for everyone?
Yes, Your Honor.
Ms. Gibson?
Yes, Your Honor.
Okay,
Yes. May I ask one clarifying question?
sure.
Okay. During this time, am I still able to have contact with my children? When I was able to briefly speak with Miss Gravina about all of this that just happened on Friday, she had indicated that that might not be a possibility. It's not like I don't have unsupervised time with my children. I'm currently set for supervised visits at both locations, and do video chats that either Mr. Gibson or his mother are essentially present for when I do video chats with the children. Am I restricted in any way from spending time with my children because it's not unsupervised time?
So this isn't properly before the court. There's a lot of things happening at the same time. There may be safety plans in place from CPS, from law enforcement, due to very specifically the statements that have been made under oath to the court about no contact with the children's alleged perpetrator. And then the massive body of evidence of contact between the respondent and that person. That's a substantial concern. So I'm just asking the court not address it today. It's not before the court. If we need to bring it back before the court, we will.
So, and I appreciate that, Ms. Baldwin. What I'm going to tell you, Ms. Gibson, is I'm not doing anything today in this action that is changing the situation. However, because there's other things going on, other things could be implemented that are outside of my control and my knowledge. So I would encourage you to continue to try to do what you've been doing and until you hear otherwise. But otherwise, I can't really go beyond that to address that concern.
Okay. So we're still operating under the current temporary parenting plan. Is that what I'm understanding?
At this point, yes. I'm not changing anything as far as that goes today. The other part of what we were doing today is reviewing the discovery and the order to compel and any attorney's fees associated with that. So let's discuss that part.
And we're also here to discuss the sale of the family home that the court had reserved on the prior order, as well as there's sort of some taxes and insurance information. So I'll just sort of argue those all now together. So on the motion to compel, the court will recall originally the respondent sort of put down will supplement, left that, didn't supplement. I believe in this case it was for more than a year. It was an extended period of time where she just made no efforts. Substantial efforts were made towards gaining compliance. Finally come back before the court, sort of feet to the fire. Court says, okay, we have an April hearing. Court gives her an additional 3 weeks, gives her a deadline. She's still late, still provides the documents late on May 1st. I'll note she didn't print them. She delivered them essentially as individual screenshots on a stick drive. The cost to print those alone was $474. And my staff had to spend hours doing it because it was like essentially spool a single document, print it, spool a single page and print it. It took hours. I'm concerned that the method used to do this was intentional. Ms. Gibson is a legal assistant. She knows sort of standard formatting and not standard formatting. Could have been Dropboxed, could have been PDF'd. Instead, we did it in like essentially the most cumbersome way possible, which is a concern. Specifically, though, the court should, when it's thinking about sanctions, turn its eye also to the AT&T records. The court will recall the phone records were a major piece of contention. Ms. Gibson said, oh, I've provided them. These were specifically the records between her and her boyfriend, the boyfriend who is now the alleged perpetrator of the child. This was a substantial concern on what their communication was, because she had said, no, I've broken it off. The children have no contact. And she provided the court recall copies of her records. Now, those records contained the phone calls with the boyfriend, but also a smattering of lots of other calls, but they looked very slight. And we even noted for the court there was misspellings that would indicated really red flags on whether or not they were authentic. At the same time, and as a result of that, we subpoenaed the records from AT&T. The records that we subpoenaed were only the communications between her and boyfriend. So the communications that you now have, or the record that you have included in your court file is only there. So the stack, the page after page after page is only the communications between the two of them. It is not her whole phone record, just their communications. There are thousands of communications, thousands that are far exceed what she provided to the court previously. What she said was the totality of the record. And the difference between the two is so extreme that there's no way she did not know. This was an intentional effort to pull the wool over the court's eyes and everyone's eyes and say, this is the totality of the conversations. But we know even up through 2023, the communications were continuing. long, a year after, long after she said that these had long since tailed off. So again, when you're looking at, and we provided the totality of what we got from AT&T, it is a brick. It's probably 50 pages. And we received that in, it was printed by AT&T in the last week of April, April 28th. We got it sometime shortly thereafter, the beginning of June. So when we're looking at this and the delays and the costs, simply even to print out her own materials, the court's award here has to be substantial. It has to be substantial, not as to just fees and costs, but also as to sanctions. Sanctions are appropriate when a party under penalty of perjury comes before the court and says, this is the totality of the record. And under subpoena, we find something extremely different. So in this case, I'm asking for an attorney fee award and costs rolled together of $5,000. At this point, we've had several hearings. I've issued her letters. That would be at least $3,500. Again, just printing the materials alone was just short of $500. My staff time to just print out the materials exceeded $1,000. I think $5,000 is a reasonable total judgment and sanction for the behavior here. As far as the next issue is regarding the sale of the home, again, these parties, one of their major assets is a single family residence. The court sort of gave the respondent time to prove she could refinance the home. She has not done so. What she has provided for you is essentially a mortgage calculator that you could go on to Bank of America and print out today. It is not a letter from a bank saying we will do this refinance for this person who has this income. She provides none of that. It is just, here's what the current rates say I would pay. And the current rates, and I'll note my client produces emails to the contrary from the bank that they currently bank at that says, no, that those numbers don't add up. We wouldn't be able to refinance somebody with that level of a debt to income ratio. She provides that the lowest possible payment is almost $1,900, which would be about 63% of her income going to that sole thing. And with that, she then would not be able to also pay child support and childcare costs. So just those two costs alone would exceed really her monthly income. There's no ability for her to refinance this home. The only answer is to sell it, and waiting to sell it is prejudicial to my client. This is a major community asset. It is a time-sensitive asset in the fact that the summer is when houses are most expensive and sell for the most money. And waiting until the dead of winter actually reduces each party's value in the home, and that goes to my client and her. I'll note that my client indicates in his declaration, Ms. Gibson's behind on child support and thousands behind on daycare costs. So this is not a situation where she's currently sort of even floating as it is, and that's with a lower mortgage cost than she would have if she refinanced. What we're asking the court to do is to order that the home be placed on the market, that it be placed on the market within the next 2 weeks. We're asking that it be, the parties use Kristen Sheetley. She's well-known, experienced. She's one of 2 real estate agents I commonly use, so this is not somebody's cherry-picked friend. If there's another suggestion, Sherry Ewald is one commonly used by many other offices as well. Either of those would be fine, in my opinion. That takes us to taxes and insurance. There's a claim by Ms. Gibson that sort of, hey, he's not paying the taxes and insurance on the home. That's not appropriate. If you look back at the old temporary order, Ms. Gibson's ordered to pay the home mortgage. The home mortgage includes taxes and insurance on the home. There's then this weird sort of spurious second line items in the order saying my client's supposed to pay the taxes and insurance as well, but that doesn't make sense when she's ordered to pay the mortgage. This was the temporary order was drafted by Ms. Gibson's prior attorney. Ambiguities go against the drafter, and in this case, the claim that my client should be paying those taxes and insurance that is rolled into the mortgage she's ordered to pay didn't happen until my client asked for payment on daycare costs. And it was only then that we received this, oh, you owe me for daycare costs. So now I'm going to claim that you should be paying the taxes on the home that I'm living in. That doesn't make a lot of sense. So we would like the court's affirmative order if possible on that as well. So given this, we're asking the court for a substantial judgment on the order to compel and order the home to be sold, order that the taxes and insurance were part of the mortgage.
Thank you, Your Honor. So first, regarding the discovery, all discovery that I've provided to Ms. Baldwin's office to date has been electronic. There's never been an objection. She's never called and said, hey, this is going to cost me X amount of dollars to print this. Each time I submitted discovery to her, I indicated in an email if there were issues opening documents or if she didn't think that I submitted everything to please contact me so we can work it out. And I received no indications from her whatsoever that anything was received. In regards to the motion to compel regarding the first discovery, that first discovery was done a long time ago. I, for the better part of 2022, spent the time without counsel. Had Ms. Baldwin wanted that discovery from me, she could have contacted me. I had no idea that that was something that I needed to regularly update for her. I will also just point out that I've not received any updated discovery from her client. I understand that's not before the court today, but so for her to say that I intentionally waited over a year to supply any sort of updated response for her, I believe is inaccurate. I'm not an attorney. All she had to do was reach out to me and say, hey, this discovery says it's ongoing. We haven't received anything from you. And I would have worked to get it to her. Instead, she just waited, filed a motion to compel, and then I had to provide all the documentation to the court, which I did. Ms. Baldwin also said that I provided all of the documentation to her late on May 1st. That is untrue. My second date to provide things was, sorry, I'm pulling up my calendar for you so I can be accurate, was April 28th. I did provide the vast majority of that second discovery to her. In my response, the thing that was outstanding was getting all of the copies of my text messages. And I had indicated in my response that I'd used multiple programs. My computer crashed. I was doing everything that I could to get it done. And I promptly got all of that response to her Monday, May 1st at 8:30 a.m. So I understand that that piece of it was not timely, but that was the only piece that wasn't timely. And I even indicated in my response to her that that was the only thing outstanding, and I was actively working to try to correct it. And I didn't hear anything from her office. Again, I've provided everything digitally and electronically from her. And this is the first time that something is being brought up about my owing fees for things. There was no CR26I conference regarding any of this. There was no phone call. There was no email saying, hey, this is thousands of pages long. You need to print this. Also, additionally, CR34, which is about producing documents for discovery, does not specifically state that they need to be produced by copies, but allows for a variety of production, including just allowing the documents available for inspection. I went a step above that and actually provided them to Ms. Baldwin, provided them in a format that was convenient for everyone using it electronically. And I do work in a law office. We send discovery documentation all the time to opposing counsels on USB drives. Yes, sometimes we send things through Dropbox, but normally our files are so large that we send them on USBs. It's not uncommon. The fact that it took her office that long to print all of that is out of my control. But again, I don't believe I should be responsible for those fees because CR34 doesn't state that I need to specifically provide printed copies of documents. I simply have to make them available for her to inspect. And I went a step above what the requirement was by actually providing the documentation to her. Had she wanted them in paper copies and saw that there was going to be an extensive cost to that, she could have reached out to me, and she chose not to. She chose to print it. There's also no declaration of fees from her office to support any of those costs, to support the page count, to support the time that it apparently took her staff to print all of that. In regard to, I believe the next thing she discussed was about the home, the family home. Excuse me. Back during the hearing in April, you had indicated to me that I needed to show that I could qualify for a refinance, not that I actually had to follow through with the refinance, which I clarified with you at a later hearing. The documentation that I provided isn't stuff that I looked up from the internet. You can see that there are emails from mortgage lenders showing what I would qualify for. The price of the home isn't set, the amount of what the home is worth, any of that stuff, that's all related to finalizing all the property assets, which is not before the court today. What the court asked me to do was to show that I could refinance for the home, and based on two different mortgage companies with two different lenders speaking to them with my estimates, that's what they said I would qualify for a refinance, and that's what I updated. So Ms. Baldwin's indication that I just pulled those off the internet is inaccurate because they're attached to emails from mortgage lenders, from mortgage companies. The home is still being paid on time. It is not being paid late. Everything is being paid. So at this time, I request that the court not order the home to be sold. This is my children's primary home. I believe another indication of trying to keep the children from having more residential time with me is to make it more of a financial obstacle for me. And I did what the court had instructed me to do and what I clarified with the court for me to do. And that's really all I can say about that. In regard to the property taxes and the homeowner's insurance, Judge Scudder, I believe it was, signed that temporary order back in November 2021. It states in paragraph form as well as in a chart who pays what obligation. It is said that I pay the first mortgage, but the property taxes and the homeowner's insurance are split equally between both parties. Yes, it is lumped into the mortgage payment, but on every mortgage statement, which the petitioner has provided some, it shows the escrow account that that money goes into and what that charge is. I've had to cover that this entire time because he's chosen not to pay it. This was already argued in front of Judge Scudder back in, it was March in 2022, I believe, shortly after Ms. Baldwin became petitioner's counsel. This was already litigated in front of Judge Scudder, and he orally ruled that he was not going to change any of the the household expenses. He was not changing any of that at this time. So now Ms. Baldwin wants to come in and try and change something that was already litigated and already ruled on by Judge Scudder. So at that point, petitioner knew and his counsel knew that he needed to pay those halves of those expenses, and he still chose not to. My attorney at the time indicated to me and advised me that I should just pay that cost if I can, and that it would be settled out during settlement. The only reason I bring it up now is I have all of these additional obligations, and petitioner's not following through on his obligation that was initially set over a year and a half ago. So that's really the only reason why I brought it up is his declaration said that I was behind on a whole bunch of things, and I'd been working from the very beginning when when childcare expenses had gotten laid out. I had tried multiple times to work with petitioner, to work with his counsel, to get those things used as an offset, and the only response was, that's not what the court order says. That's not what the court order says. It very clearly indicates in two separate ways that that is how it is. It's never been changed, and that ruling, I believe, because it's never been altered in any subsequent order, is still valid. And then there was the issue about child support I pay that through the state. I was not aware that there was any outstanding balance. So I can call that division, I forget what their proper name is at the moment, so I apologize, to see what is going on with that. But that's continually paid. It's continually coming out of my paycheck. And the only thing that I ask in terms of that, in terms of any sort of outstanding things, is that we're able to use the outstanding homeowners taxes and property taxes, homeowners insurance and property taxes, offset the current childcare costs. I shouldn't have to bear the brunt of all of these financial obligations when for over 2 years, petitioner has blatantly not paid a court ordered expense. And then it was already litigated in front of Judge Scudder. He decided he was not going to change anything at the time, and it's continued to not be paid. So I've had to suck it up and pay it so that the house stays current, so the house stays in good standing, which I've done. So just in conclusion, I've complied with all of the discovery requests as well as I could. I sent emails to follow up with things were missing or things couldn't be opened. I got no response. I've tried to just comply the best that I can. And I don't believe fees are warranted in this case, because I, again, provided everything that was requested of me. My AT&T records, I pulled those directly off of my AT&T account. That was the only way that I was told by the local AT&T store here in town, as well as the customer service, that I could get them outside of going to the corporate headquarters, which is located in Texas. Looking through all of those documents, I'm having a hard time reading it and understanding it. But what I provided to the court was accurate from my AT&T account. I don't know how those differ from the business accounts that AT&T produce. But everything that the court ordered, or that the court had indicated for the GAL to review, was everything from November 2022 to current. There's just a handful of stuff there. Everything else prior, the court knew that there was contact. The only restriction on the contact was for him not to be around the children. Having phone calls doesn't indicate that anyone was around my children. We're not together. I haven't spoken to him. I can't even respond to the declaration that petitioner's mother filed for today. I believe that that's all hearsay, indicating a conversation that she overheard between two parties. Petitioner didn't even put it in his declaration. The only person who would be able to accurately respond to that would be Mr. Rosales, and I don't have contact with him because the court has said that I can't. So I feel like it's almost a trap sort of set up in order for me to get any sort of response. I can't even really respond to anything that's said in there. That's the first that I've heard that there was an alleged conversation. I feel like if there was a conversation like that. It would have been brought up before the end of May. I don't know when that alleged conversation occurred, but the only person who could potentially affirm or contradict that is Mr. Rosales, and I can't contact him because of current court standings. So I believe all of that is hearsay at this point because there's no evidence to support that a conversation even happened. So I apologize. I was a little bit winded, Your Honor. But I don't believe fees are appropriate in this matter. I did everything that I could to comply. As I'm not an attorney, I did the best that I could. Ms. Baldwin could have very easily indicated to me via phone or via email if anything was missing or if I needed to print anything out, and I had zero contact with her. So I think any awarding of fees at this point is not reasonable.
The court goes back and looks at the correspondence attached to the February 22nd, 2023, and to the statements in the March 21, 2023, both motions to compel. One has a laundry list letter attached that I sent to Ms. Gibson, details the efforts to get her to comply. Same with the March motion to comply or motion to compel. So again, we've made significant efforts. There's a big difference between, hey, they didn't ask me to supplement and or ask me to update versus I said I'd supplement and I just never did. I just ignored the fact that I said I would give this to you later and then just decided not to. It's very challenging when someone says, I still am not having contact with him, and the text messages, so the phone logs show text messages and phone calls, and at some point AT&T had to cut it off, but we show text messages between the two of them all the way through March 28th of 2023. And again, AT&T has to cut it off somewhere. So to continue sort of this facade at this point is just futile. I don't understand it. But regardless, it costs to subpoena things. And the only way we would have obtained these records is by subpoena because Ms. Gibson hid them. And there's no other explanation, especially when we have misspellings in the materials that she gave us that were supposedly native records. The fees that we've asked for are reasonable. As far as child support, again, the claims that I didn't know that I owe daycare costs, just ridiculous. There's no other word for that. She's very aware that she owes daycare costs. It's in black and white in these orders. The home sale, a home should be sold. What she provides literally says loan program scenarios. There is nothing saying that she would qualify as an actual refi. This is a mortgage lender just running through general scenarios of cost. If you're refinancing X dollar, this is what your rate will be, but not in any way that she would qualify to refinance. It is prejudicial to my client to not sell the property. The children don't live there. It is not their primary residence. Their primary residence is with their father, who lives up in Spanaway. We're asking the court at this point to order the home sold, order fees, and give the relief requested.
Right. Thank you. So I do have a little bit of a concern with the communication between, I'm going to start with the house, the communication between Ms. Gibson and Mr. Betneski from Guild Mortgage. And I understand Ms. Gibson's position that, this is what he's saying, but clearly it was don't run the credit. He didn't even confirm, he just ran numbers in a scenario that was requested to me. And I made note of this when I received the declaration affidavit that this doesn't satisfy the court that there would be a ability of the respondent to refinance. When we don't have the credit run, we don't have anything saying that she 100% qualifies and could do this, just the scenario, and here's the numbers. So that's concerning. I did set a deadline for that for the 16th, I believe, of May. The declaration was filed on the 12th. But when I reviewed that, and I sit here today still not thinking that's unfortunately sufficient. As for, I'm going to kind of jump around here a little bit, and I apologize for that. I understand the taxes, insurance. I understand that and I believe Ms. Gibson cut and paste part of the original order in her responsive declaration that basically outlines this is separated out. That's to be frank, kind of strange. I've not seen an order that does that way. Almost every order has the property taxes and homeowners insurance as part of the mortgage and not separated out. That being said, you'd read the order as it sits, and it does indicate that the party shall place or split 50-50 all other community bills, including credit cards, or excuse me, excluding credit card debt, including but not limited to the HELOC, property taxes, and homeowners insurance. So I understand Miss Gibson's frustration with that. And I do see it would be about $168 per person every month. And she totals that up to $3,028.50 in arrears for those two things. I don't know that she's officially filed something asking for that relief. So correct me if I'm wrong. She may have.
I have not, Your Honor.
Okay.
I didn't understand what to do.
So at this point, here's what I'm going to do. Ms. Baldwin, you're not are you available on the 20th? The 20th is closed. Did we close the 20th, Ms. Wade, or did we close the 13th?
The 13th.
We closed the 13th, but you're not here the 20th, Ms. Baldwin?
That's correct. I could be available the 13th or the 27th.
Okay. In regards to the discovery and the request for attorney's fees and costs, I'm gonna grant some attorney's fees and costs. We had a motion to compel. I basically stayed the request for attorney's fees to see if we could get the discovery completed. I do have some concerns that, and I did a cursory review of the kind of comparing the phone records, and there are some pretty distinct differences in those phone records. So that is concerning to the court because it does appear as though, I mean, there's differences that are concerning. So I'm going to, as far as any attorney's fees and costs associated with discovery, I'm going to impose $2,500 in fees. And then as far as the house goes, I understand it sounds like Ms. Gibson is very much wanting to keep that house and believes that she can. So we're going to set a review and then presentation for June 27th at 1:00 p.m. If I have, Ms. Gibson, from you, something that says that I can refinance, the credit check has been done, and I can have the refinance done by X date and pay off the numbers that are appropriately needed to pay off Mr. Gibson, then I will consider allowing the refinance. If we don't have that information on the 27th of June, then I'm going to grant the request for the sale of the home. So it's really pretty much cut and dry. That there's
Okay.
no, and I just ask that you get that information to the court and the parties, because I understand some of that can take some time, maybe by sorry, I'm looking at the wrong month here, no later than the 23rd, just so we have an opportunity to review that and council can make any phone calls or inquiries as needed before the 27th.
I want to
Okay.
clarify, the home should be set at, for this purpose, and not any other purpose. The home should be set at a value of $400,000. So it's not that what I don't want her to do is go get essentially a payoff refinance. The CMA says essentially $400,000. That's what we should set it at. And that's what she should have to refinance at that value.
I would agree.
I don't understand. Can someone please clarify? I'm just trying to get my numbers correct.
Okay, well, you can't just say, well, I owe this much and I need to pay him X much, so I'm only refinancing the payoff amount plus the amount. You need to be able to refinance the entirety of the home to take that on. I understand that, and it may not work out to be that ultimately, depending on how everything works out, but you need to be able to take on the refinance of the entire home under your name. So that means credit will likely need to be run. We need confirmation that, yes, we can do this. It's just a matter of signing the paperwork. So that's what the court's looking for.
Okay.
If you run into any issues with that, Ms. Baldwin's office is available and is happy to have a discussion with you. We're not going to discuss it further here. So at this point, what's before me? GAL, we already set a date for Ms. Gravina to come back, and that's August 8th at 1 p.m. we're setting a review and presentation for June 27th at 1 p.m. for the orders on fees that were imposed, and to review whether Ms. Gibson is able to refinance the home with the ability to make a payoff that is necessary to the petition. So we'll see you all back in about a month on the 27th at 1 p.m. Do we have, I see Miss Holloway, Mr. Zandy, and then we have Mr. Zandy. All right, this is a contempt. I have reviewed everything, so I'll defer to you, Miss Holloway.
Did our parenting plan, whether following that ended 2 weeks ago, or that ended 2 weeks later on April 21st, or the CR2A agreement from the previous day, the orders were broken. Our son was in my care March 17th to 19th and was due again on the first weekend of April, which was April 7th to 9th. Mr. Falk denied that visit, stating that it was not the first weekend of the month. When I attempted to clarify the plan for him with screenshots of websites explaining the numbered weekends, calendars that demonstrated our plan, and various other explanations, he angrily denied my claims. I politely offered to let him clarify with his attorney's office and make it up the following weekend, but he only became more angry. He ended the conversation stating, "I guess since you want to make this the first weekend," and then he won't coming until 4/21 weekends.
Wait, Ms. Holloway, I'm going to pause you for a second. You cut out a little bit there and we missed some stuff. I don't know if maybe turning your video off would help with that. But you got cut off after you, the portion where you said that you asked him if he wanted to talk to his attorney's office.
Okay, I'll try turning the video off.
All right.
I politely offered to let him clarify with his attorney's office and make it up the following weekend, but he only became more angry. He ended the conversation by stating, "I guess since you want to make this the first weekend, then he won't be coming until 4/21. He effectively told me that after having our son the previous 2 weekends, he would continue to keep our son the current weekend and the following weekend, adding up to 5 weeks between visits. This isn't consistent with the temporary orders we were under or the not yet active new orders he claimed to be following. Furthermore, he involved our son in his anger that evening. Instead of hammering out the problem with me and informing our son of where to be and when, after reaching a resolution, he encouraged our son to text me and argue with me about the issue as well. Our son was arguing the exact same point as Mr. Falk, which would indicate that they were discussing the issue together. 1 week later, on April 14th, Mr. Falk again involved our son, using him as a pawn. Our son came to my home that day after school. I had no idea he would be there, as Mr. Falk clearly told me that I wouldn't see him until April 21st. Our son made plans with family for dinner and a movie and told us he was leaving for work a little early because he needed to get his glasses from his dad's house. While we were discussing our plans in Camden State School, I texted Mr. Falk and asked if his intent was for this to be a makeup weekend and what I should expect moving forward. He responded, "This was your weekend, which is what we discussed. Even said he'd be there this weekend." I pointed out that instead, I received a text and he read, "Okay, so after work, I'm going to grab my stuff and I'll be back next weekend." I asked why, and he said, "You guys weren't apparently expecting me to begin with. And also, if we're going to follow the new schedule, it would be yours next weekend." Mr. Falk told him to spend the weekend at my home and then yanked him back when I asked for clarification so my family could plan our next few weekends. It's clear by our son's text messages that Mr. Falk was in violation of our involving him in these matters. Mr. Falk has a history of withholding, which is the reason I contested his petition last fall. And I feel at this point that contempt is my only recourse. If not penalized, he'll continue to withhold and violate the plan as he sees fit because he knows I can't do anything about it. So I'm asking the court at this time to find Mr. Falk in contempt and impose sanctions.
If you look at the history of this case dating back to last fall, how we arrived at this point, it's very apparent to see that this motion, quite frankly, was not brought in good faith. And the motion itself, Ms. Holloway, is asking you to consider and find a contempt on the November 2023 parenting plan, temporary, that she incorrectly cites. I'm assuming she's going under the guise of the November 2022 parenting plan. But nonetheless, that's improper to do. If you look at the timing of that, that was the second parenting plan that was in effect. Now we then go to mediation in early April on the 6th. We come to a resolution. A CR2A agreement is effective April 7th of 2023. We then get the motion for contempt based off of the existing November 2022 parenting plan, which again is superseded by the CR2A agreement. She cites specific acts from after that CR2A agreement, which again, on its face, the motion for contempt fails. That CR2A certainly supersedes whatever happened prior to that. And not only is she going back to the November plan asking you to find contempt, also asking you to go and find contempt prior to that from the September parenting plan. I was quite simply confused by the motion. I had to review that a couple of times, as did my client. You get my client's response to that, but again, on its face, this motion is insufficient and does not comply with the law. That's first and foremost. Second of all, if you look again at the history of this or the basis of the contempt, she's alleging that my client violated that by essentially attempting to give her an extra weekend in the month of March, which she turned down. Existing order says from then, or what she's alleging, the temporary order cited that she gets the first and third weekends. My client attempted to give her the first, third, and fifth weekends, not understanding that that was the first weekend of April. Nonetheless, she denied that and essentially sends the child home. This is a child who is now 17 years old and drives. My client has to tell him what the parenting plan is and the structure now, because Camden is essentially transporting himself to and from these visits. He shows up at mom's house. She acts surprised. She essentially said, "We're sick, go home." He does. He tries to go back over there later. And again, this was after the CR2A had already been entered and is told it's not my weekend, essentially go home again, without realizing the effect again on the 17-year-old kid who looks at mom and says, "Well, I don't understand why it matters whose weekend it is. If I'm here, why can't I just have the weekend with you?" He said, "That's not the way we're going to do it." We enter into the CR2A agreement. We're drafting final papers. We had expected that was all going to be ironed out and done. Judge Evans made that perfectly clear. My client, again, which is not uncommon, takes a while to transition to the new plan, which went to every other weekend to avoid the very problems that they had with that first and third weekend identifiers through the temporary basis. We agreed to that. Only to 5 days later, she filed this contempt for something that happened on the weekend of April 7th through the 9th, which is different on the final CR2A and final orders than there was in November and September of 2022. So again, looking at this pragmatically, I really have no idea what it is she's alleging. Now, what I will tell you is that she was found in contempt on prior hearings. The relationship she has with Camden is strained, to put it mildly, based on these very types of actions and activities. And to expect a 17-year-old not to insert himself when he has access to a cell phone, he has access to his own car, he has access to a job, tries to do the right thing by going over to mom's house, was just on the wrong weekend. Instead of welcoming him with open arms, she said, "Nope, go away. First time we're sick, second time because it's not quote unquote my weekend," when it was her weekend under the CR2A. So again, a contempt has to be willful and intentional. Now, there's no showing of that. There's absolutely no showing that my client impacted the child or communicated with him in any unreasonable or unnecessary terms. He simply told him, "This is your mom's weekend, the schedule has changed, and this is what it is, drive over there after school," which the child tried to accommodate, the child tried to do, only to get rebuffed and turned away by mom. And looking at this, and again, this is one where I hate to use the F word in open court, but this is frivolous. Now, this is a case in which there is no legal or factual basis for this. Mom has unfortunately been consumed with finances. And my client does detail for you the fact that she's paying a mere $100 per month in child support. That was what was believed just to be over and done. That's a significant break to her. Basically, the cost of this motion is a year's worth of child support that Miss Holloway is paying my client for care of an active 17-year-old. He's now paying for legal fees and costs associated with no other reason than mom just trying to basically get the last say in this matter and rectify what she was found in contempt for a couple of months ago, which the GAL and I believe it was Judge Nelson at the time said that that's absolutely inappropriate what you're doing. She now comes back and bases a contempt motion off of a parenting plan that has long since been superseded by the final orders that were only very recently entered through that CR2A agreement through mediation. My client is asking for contribution, attorney's fees, and costs. This motion is completely baseless. It has no factual or legal basis, as I mentioned prior. And this is one where Ms. Holloway needs it made abundantly clear to her that this is not how the law works. This is not the spirit of the order. And sending your 17-year-old child away just simply so you can set up a contempt motion, again, does nothing to repair that relationship that is strained between her and Camden at this point. This absolutely should be denied. And we believe that a reasonable contribution towards fees and costs is appropriate. Your Honor insinuated to her a couple of weeks ago when I agreed to accept service via email on my client's behalf, just so we could have this matter heard, that there were some complications with the motion just on its face related to alleging a contempt for a November order, which had been superseded by a CR2A agreement. Nonetheless, we're here. I certainly tried to communicate, and as did my client in his declaration, that this was improper. But now here we are going into hour 2 of this docket, waiting to hear these arguments on something that just doesn't have a legal basis. Now, we do believe that a finding of bad faith is appropriate. A finding that this motion was frivolous is certainly appropriate. and an award of fees and costs is also appropriate. My client has asked me the amount of $1,200. Again, given where we're at with the child support and the fact that he is providing nearly 100% of the financial, emotional, and physical support of this child, we believe that is extremely reasonable.
Thank you, Mr. Zandy. Anything else, Ms. Holloway?
Yes, a lot of what Mr. Zandy is saying doesn't line up with what actually happened. I don't know how in-depth you reviewed the text messages or Mr. Falk's response and my response. But the weekend that they're saying we sent him home because we were sick was actually the week prior to the CR2A. And that was just a text message from my son where he asked if he said he was out of school early and asked if we wanted breadsticks. And I said, hey, because we're sick. And had no idea he was trying to spend the night. It wasn't our weekend. We had no idea he was trying to spend the weekend with us. I just thought he was bringing food. So he brought food anyway and dropped it off and he went back. The following weekend was supposed to be ours, which was the day after the CR2A. So Mr. Falk and Mr. Zandy are feigning confusion over this. But if we didn't have him the last weekend of March, then if they were truly following the new orders, we would have had him the first weekend of April. No matter which plan you look at, the temporary orders or the CR2A that we agreed to the previous night, and if you just say that they're confused about that and whatever, that's fine. Then the following Friday would have been our weekend. If they claimed the 7th was theirs, then the 14th would have been mine. But instead, he sent Camden. At this point, he didn't know I'd filed contempt. I already filed contempt. He didn't know yet, and he sent Camden to my house. And then when I texted him and said, hey, we didn't send Camden away, first of all, at all. And I think the text messages from April 14th between Michael and I and Camden and I show that he was not sent home by me. I said to Michael, this was your weekend, or I said, you said we wouldn't have him this weekend and he showed up with no communication. So what's the plan? Is this a makeup weekend? Is he here next weekend or just this one? I need to know so we can plan the next few weeks. Thanks. He said, this was your weekend, which is what we discussed. Even said he'd be there this weekend. I said, it's not our weekend because we're still, until April 21st, we're still under the November temporary orders. I said, it's not our weekend. Nobody said he'd be here and be here 4/21. He never responded. I'm assuming he went back and looked at his, said, you'll see him for. So Camden went to his dad's to get his glasses before work. And when he got to work, he sent me a text message that said, okay, so after work, I'm going to grab my stuff and I'll be back next weekend. If I sent him home, if we had a conversation with him about how he wasn't welcome because it wasn't our weekend, there would be no reason whatsoever for my son to reach out to me and say, I'm going to grab my stuff. I'll be back next weekend. I asked him why he said that. He said, you guys weren't apparently expecting me to begin with. And also, if we're going to follow the new schedule, it would be yours next weekend. None of that indicates that I told my son to go home. That very, very clearly sounds like he got home to get his glasses and dad said, hey, your mom wasn't expecting you. You need to go back next weekend. So that would make the 4th weekend in a row that we didn't have him because he came over after work at 10 o'clock at night and got his backpack and went back to his dad's. And there, Mr. Zandy and Mr. Falk brought up all kinds of things about me being in contempt and financial things and all these things that are not relevant to this matter whatsoever. Yes, I was found in contempt. Yes, that was frustrating. Yes, I'm paying $100 in child support because I don't work and I have 3 other kids. He didn't settle on anything. He didn't give up child support. He got a tax return he got tax returns in exchange for $50 a month. So they're blowing it up and making it sound like some big retaliation thing or frivolous. There's nothing frivolous about being upset and wanting sanctions for someone that withheld my son for 5 weeks. And there's just nothing frivolous about that. He needs to understand that he cannot just decide that he can change the plan whenever he feels like it. His withholding is what got us here in the first place. And I believe that's all I needed to address.
Judge, I just object anything that wasn't part of the initial declaration and again, rest on the CR2A, which I don't believe specifies when the weekends started, whether that was the 7th through the 9th, the 14th through the 16th. I think it was.
There's a few layers to this. I understand everybody's frustration. I understand Ms. Holloway's frustration, and it appears as though whether it was real confusion, feigned confusion, that she felt slighted in some way for the miscommunication, confusion, whatever it was with the weekends. Here's where I'm at. In doing a quick, I haven't been on this case for a very long time. I think I took over the stock at the beginning of the year. I've seen the parties maybe a handful of times. And I guess, Ms. Height, did you have anything that you wanted to add? I know that you're here and you're a GAL on this case.
I'm really just observing, but I would let your honor know that I have not spoken to Camden in quite some time. I found him to be a gentle, thoughtful young man, and it is, as I sit here, it is troubling to hear that these parties are still squabbling over this. They're leaving, in my view, a shameful legacy for a young man who's on the verge of doing his life independently. And it is my great hope that they will be able to come to a conclusion that is in his best interest. I believe that they are in the, I understand that he needs to have some communication about this because of his age and his ability to drive places, but I believe that their contact about this has gone past communication into conflict. So I know that's not very helpful for today's decision, but I appreciate the opportunity to state what I had to say. Thank you.
Thank you, Ms. Height. Sometimes it's just good for parties to hear. Here's where my frustration lies. We have, for all intents and purposes, a successful MSC where we come out of it with a parenting plan that a final parenting plan for a young man who was on the verge of adulthood and clearly very self-sufficient. I mean, if he's driving, working, going to school, doing all these things, he is kind of put in the middle of this. It couldn't be simpler. The new plan every other weekend couldn't be simpler. Here's where I'm at. I've reviewed the dates, are just everything about this is a little bit confusing. I understand that there's, okay, the CR2A was, looks like the modification and the final parenting plan from the CR2A were signed off on the 21st of April by the court. This looks like the 17th and the 19th, respectively, of April by the parties. So, arguably, did it take effect as soon as that MSC was done, or when the actual parenting plan was entered? I suppose we could have a further argument about that. I'm not going to make a finding of contempt. We need to put our adult pants on and realize that there's a kid here, that this isn't a tug of war over a thing. It's a young man who is learning from what you guys are showing him. The notes that I made are, this is a child, and I probably shouldn't quote the rest of what I'm saying, but this isn't a power struggle. I'm not making a finding of contempt. I think, frankly, this young man is probably much more aware of the contention between the parties than people realize. It's probably very difficult to keep him completely excluded from some of what's going on, and he's probably seeing that. And my hope would be that, and I'm not awarding any fees to anybody, my hope would be that this every other week, it's pretty simple. Do we know now? Does everybody understand which weeks are which?
I do.
When's the last
I
time,
can't
Ms. Holloway, you had Camden?
April 21st. No, sorry. Not this weekend, but the previous weekend. I don't have a calendar on me.
So the week
Get
of
him
the
this Friday, I
19th,
should say.
19th to 21st, you had him?
Yes.
Okay, so
Yes.
you would be getting him this weekend.
Would it be possible to, whether I could do it or Mr. Zandy's office, but you simply write up a calendar that says, maybe mom or M on every weekend that's mine, so that Mr. Falk knows that that's how it goes. In the past, like we had him for Easter weekend last year, and he decided to reset the every other weekend because we had him on Easter. And that's kind of how he's done this the whole last couple of years, is he resets what every other weekend means based on me having him for a holiday. Concrete calendar for him. I think it would clear up hopefully all confusion for him. Then he can add in holidays and birthdays and summer visits and things like that.
You want me to answer that?
Sure.
No, I'm not willing to draft a MMDD on every other weekend because it's so simple. We have a 17-year-old child who has, again, a job and everything else, and the parenting plan accounts for that. and they've got a 17-year-old child born as issues together, if they can't get along at this juncture of time on what an every other weekend schedule means, then I feel sorry for both of them. My client knows what that is. I will make sure that he does. And then it's going to need to foster some cooperation between two parents to figure out whose weekend it is and be reasonable and accommodating of the child's schedule and each other's schedule. I don't think that's a very valid request. So no, I unless the court tells me to, and Your Honor, obviously, if you think that's necessary, I will talk to my client about it. But my initial knee-jerk response is heck no to drafting them, two adults, two parents of a 17-year-old, a calendar showing whose weekend it is.
Well, and frankly, I agree with that. At some point,
So do I.
we, so if the 19th through the 21st was mom's last weekend, mom's next weekend should be this weekend, the 2nd through the 4th, and so on and so forth. So, Ms. Holloway, if you want to draft a schedule like that for your son, that's perfectly acceptable. Obviously, there's a handful of holidays that may alter that slightly, but otherwise, I guess I'll have Ms. Height note, Mr. Zandy note, Ms. Holloway note, that the court is seeing the 2nd, 3rd, and 4th of June as mom's weekend. And if that needs to be the definitive date that we're using moving forward for every other weekend, then that'll be it. So my hope is, I don't know the entire history of the parties, but you're adults, you're raising a practically adult at this point who, from everything that I've read, appears to be a very good young person. And so you're clearly, parties are doing something right. And I would hope that you can figure out a way to work this out moving forward. So
sorry, I didn't mean to interrupt.
No, go ahead.
You want to issue just a quick handwritten bench order to that effect of the denied, and
I will do a bench order just denying the contempt and both parties' requests for fees. Here, Ms. Kaufman,
Thank you.
Mr. Kaufman, and both
Your Honor.
counsel. I have read the GAL report. Thank you again, Ms. Height, for getting that to us in a timely manner. And I know that Ms. McLean, I believe, had some questions, concerns with that report. So if it's okay with Ms. Baldwin, or was it you, Ms. Baldwin?
Well, so we're really here to review the plan, so not just the report. So the court reserved essentially really the whole, I would argue really the majority of the visitation time, both the standard school schedule and the summer schedule and holidays are sort of left for today. And we kind of limped along to get to here because you wanted that report before sort of issuing some orders on those things.
Well, and of course, my understanding was that the reason why we are here was to not only receive Ms. Height's final order and recommendations, but to take a look at what would happen for the summer. Do I think it's necessarily appropriate that we're doing potentially a full-blown parenting plan on a final GAL report without the parties really having an opportunity to weigh in and be heard? No, I don't think that that's appropriate. I think that's why we set testimonial hearings in the future, so that everybody and the court has the ability to hear all of the evidence and information. I think pointedly, the report does seem to indicate that the girls are still having difficulties. The girls were very clear in their statements to Ms. Height that they liked things the way that they are. And of course, the concerns are, if you push these girls too hard, are we going to have a worsening of their ongoing issues? I am a bit concerned that perhaps not all of the counselors were talked to. I know Ms. Height had talked to me after the fact, that apparently one of the counselors, Ms. Wozniak, had reached out to her after submitting her report. But nonetheless, I think it's appropriate when children are in counseling that those counselors be spoken to or talked to, and that they provide input, because obviously when we're talking about children, they don't know what's in their best interest. They don't know necessarily where they're at on their own mental health. And I think it's important to have those third parties provide that feedback. Regardless, these girls are still in transition. They have indicated that they like the current visitation schedule, which is the first and third weekends from Friday to Saturday. I'm sorry, from Saturday to Sunday. And you'll note that Paige, while Dad indicates that he's happy for Paige to be able to go do things on his time with her friends and the like, she has consistently been away, not spending time with Dad, which again, I think is significant and telling as it relates to her relationship with Dad. Frankie continues to have difficulties spending the night, and often she is allowed to return early. So again, allowing these children that flexibility and providing for the current visitation schedule to continue perhaps through the summer schedule when they are off of school and allowed to maybe have more of that one-on-one time with Dad, I think would be appropriate. So our position is that the court should maintain the existing visitation schedule, which is that first and third weekend is defined by Fridays from Saturday at 10 a.m. to Sundays at 6 p.m. I note that there was some information in the guardian ad litem's report about a domestic violence evaluation for Mr. Kaufman. My client has not had, my client had some input on that. I have seen no report on a domestic violence evaluation. I know that the feedback that my client had received from the evaluator was that they were surprised that the court hadn't ordered domestic violence counseling. And based on the information that was being provided, it sounded as though domestic violence counseling should have been ordered or was being recommended by the provider. So as we sit here today, I have not seen a DV evaluation or what the results of that are. I've not yet requested Ms. Height's file. Of course, I'm assuming she's got a copy of it. I'm assuming, I'm not certain. But clearly that's information that would be important for the court, particularly since this court called Mr. Kaufman out in open court about his behavior directed towards my client during visitation exchanges through the text messages and the like. And I think that that's also going to speak volumes to his ongoing relationship with his girls. The other concern that we have is that at this point, because there has been the limited or even though there's been the limited contact, the paternal grandfather has still been speaking inappropriately in front of these girls. The girls reported that information to my client. The girls reported that information to Ms. Height. Ms. Height talked to Mr. Kaufman about that, and he assures her that his father does not need to be present. And we're asking for an affirmative order that Dan Kaufman not be present during the girls' visitation. If Mr. Kaufman is going to be successful in correcting his relationship with his girls, then that request should be honored. And again, if you recollect back to the time that you were admonishing Mr. Kaufman about his behavior, you were very clear that if this court heard about any further ongoing violations of not talking in a disparaging manner or allowing any third parties to talk in a disparaging manner about the other parent in front of the children, that you would deal with that very harshly. You provided that as a bright line. And yet we still have this going on and being reported to the guardian ad litem. So I think the bright line is Mr. Kaufman, the elder Mr. Kaufman, Dan Kaufman, should have absolutely no contact with these girls because he can't seem to mind his mouth. The suggestion is that, it was taken wrong by the girls. Shouldn't have had any type of a discussion where there would have been an opportunity to be taken wrong by the girls. If you're going to engage in those kinds of discussions, you do that on your own time when the girls aren't present. So we're asking definitely for an affirmative order that Dan Kaufman not be present during any of the father's visits. In regards to extended summertime, I agree that it's just too soon. I think in my discussions with Ms. Height, she acknowledged that extended summertime is too soon for these girls. I'm assuming she's going to provide some further feedback for that. If you are inclined to provide anything, that we would ask that it be limited to no more than 3 or 4 days, and let's see how the girls do. But again, the hope is that the girls with time are going to be able to rectify their relationship issues with their father. But every time they're put in a situation where their mother is maligned in front of them, or they're having to feel like they're coming to his defense or her defense, or they're having to correct his feelings of being lonely. Most recently are the discussions about how lonely he is in his house when they're not there. That type of guilt does not lay a positive foundation for a future healthy relationship with his girls. So while I understand that he's taken the high conflict parenting class, clearly he's not getting the message. He probably would benefit greatly by some appropriate parenting classes that teaches him how to parent, how to engage in appropriate communications with his girls. Because again, these are young ladies. And what he's modeled so far is that it's appropriate to speak ill of your other parent in front of the girls. And it's appropriate to engage in that abusive type of behavior. We want that to stop, especially given the fact that my client is no longer present in a marital unit to be able to be the buffer for those girls as she was in the past. So we're asking that you take things slow. that he needs to show that he can act appropriately, talk appropriately, protect these girls from third parties, even if they're family members, from talking inappropriately, and allow these girls to move on at their own pace.
Right. Thank you. Ms. Baldwin.
Thank you. Counsel's recitation is really an extreme example of spin. And that's true when you look at the guardian ad litem report, but also true when you look at the pleadings in this case. So number one, these girls are transitioning. No, they're not. Case has been filed for a year. These parties have been separated for more than a year. So the idea that this is fresh, it's not. This case was filed in May 12th of last year. We're past the transition phase. Number two, when you look at mother's originally proposed parenting plan filed back in May of 2022, no 191 factors, there's no other concerns, no concerns of either parent. So again, as May of a year ago, there weren't concerns. So all of these, like, I'm so concerned, this has been a horrible relationship. No, the parties then go from May to November cooperatively with essentially agreed temporary orders that they just sort of worked it out and worked amongst each other for an extended period of time. Then we see in November, Mrs. claiming essentially an assault to strangulation, where law enforcement investigates and the facts are so unbelievable, so questionable, and lacked such credibility that even law enforcement was like, no, like they couldn't find probable cause based on her statements. So then we go to this statement that, and I think that that's where you start to see this transition of, oh, well, now if I force this narrative, then I can get my way. And I think you see that again where Dad got called out early, Your Honor, on, hey, you can't talk to her that way. And my client cleaned it up. They then report to the court that that's continued, but they don't present any evidence of that. So they present none of it. They act like it's continuing today, but they present you with nothing. There's plenty of time for anyone to have filed anything prior to today, not a shred. And in fact, they called my client out and had Your Honor call my client out back in our March hearing. And after that, I contacted the GAL and I said, hey, is this still going on? Because you alluded to the court that this is still happening. And the guardian ad litem responded back to me, oh, those were back from August and September of 2022. And that's something you can clarify because I have those emails and you can clarify with the GAL. So again, my client did take the high conflict parenting course. He did clean up his act. He's done everything the court would have wanted him to do. But what we see is sort of like, let me keep spinning this narrative because it works. And I can keep saying that this is a transition to prevent my client, to prevent father from having real time with these children. Let's look at the guardian ad litem report. Guardian ad litem report says both parents are engaged and loving, that they have healthy signs of cooperation and that both parents are focused on the children's needs. Counsel sort of makes it this negative that my client allows the kids to do normal kid things instead of my client being like, yeah, I'm not going to prevent you from going to Susie Q's birthday party because that's important to you, or going to the dance because that's important to you. Those are normal childhood experiences that my client isn't denying the children. And that's spun as a negative, when the guardian ad litem report really makes that a positive, that he's doing the right thing by his children. The court should look back at the December 16, 2022 plan. That plan was the father was to have essentially first and third weekends, Friday to Monday morning drop off at school. The court reserved the issue of fifth weekends and reserved, I think, the issue of midweek visits. If the court adopts a straight every other weekend plan, a Friday to Sunday plan, that limits a parent to 14% of their kids' lives. It's nothing. Are you an aunt? You certainly aren't a parent if you're seeing your kids only 14% of the time. That's so little time to actually have experiences. And part of the time those kids are sleeping. So it really limits a parent's time. And this idea that allowing Susie Q to go to the birthday party or do this event, if you only see your kids every other weekend, you almost can't do those. You have to say, no, I have to see you because this is all I have. I have to guard it. The only way for parents to act rationally is for them to have enough time to say, yeah, that's okay. You bet your kiddo, because they have to have enough time otherwise to see those kids and to connect. So we're asking the court to essentially go back to the December 16th, 2022 plan, which is Friday to Monday morning drop-off. That prevents the parties from communicating and having contact, which is a positive. Number two, the court should add in the fifth weekends. There's usually only 4 fifth weekends a year, so that's not the end-all be-all. And we're asking for a midweek visit every week, Wednesday from after school to 7 p.m. My client understands that there's sports practices, activities, honor club, society. He's going to need to get him to those things. He understands that. But these are opportunities to connect to the children. Second, when it comes to the summer, my client is seeking the average every day, two non-consecutive weeks with the children so that he can have normal summertime. Again, the guardian ad litem found no 191 factors, found no factors at 3B, no red flag concerns. So we're in a situation where what we're saying is, well, mom's made some allegations and none of those are really panned out, but let's keep withholding from dad. Even though we're a year down the road, let's not give him any real summertime to have any trips or vacations or be able to do anything to build those memories for one more year. Let's hold off. That's not reasonable. That's not reasonable in the case where we don't have 191 findings. Arguably, this should be more than a 2 weeks, but my client says, let's start with 2 weeks. That's reasonable. And again, he's not even asking those to be consecutive. The court should also place standard holidays in the plan. The idea that we're going to deny my client regular holidays, 3-day weekends, all of those typical things, that's just, there's no basis for that. There has to be some kind of basis to limit, and there just isn't here. Again, we're a year out. This is no longer transition. And even Guardian Lineup says everybody's doing really well. Everybody's sort of moved on and moving forward. I do want to address the restrictions on the parental grandfather. There are no statements that man made in the Guardian Litem found except the statement of you'll always be a Kaufman. That's not a negative statement. That is not your mother's a blankety blank or any kind of discussion about the case. It's I love you, kiddo, and you'll always be part of our family. That's a statement of support. This statement where child says, I felt judged. That's not really youth speak. I don't think that those are words that a young person uses. I think those are words that are parroted from a parent and that the parent feels judged, not that the child is. So in this case, the idea that my client who lives with his father is going to be banned from the home, it doesn't make any sense. No one said anything inappropriate to begin with. We have an odd perception of that statement at best. I think it's more of a statement from a parent that's parroted by a child who feels that they have to align. So again, in this case, we're asking the court to adopt a first, third, and fifth weekend from Fridays at 4. So my client's asking, allow kids to come home, drop off what they need, pick up what they need. So I don't need to take a bag to school type of a thing. But my client takes them to school on Monday mornings. Normal holidays, 2 weeks in the summer, Wednesday day visits after school with my client transporting to normal activities. That's a normal parenting plan. It also is in the best interest of these children. They are at a place where it's time to move on. Mother's case hasn't panned out. The facts that she's sort of alleged aren't really there. And we're in a place where these kids need to have good, solid contact with both parents. And if the court adopts my plan, this is not a 50-50 plan. The court adopts just those extra little bits of time. It gets my client to about 20% of the time. He just wants to have enough time with his kids to build and maintain a solid foundation of relationship with them and to not feel like he has to withhold them from normal kid experiences because he has so little time that he has to guard every minute of it.
All right. Thank you. Ms. McLean.
Oh, did the court want to hear from Ms. Height?
I can do that before returning to you. That's fine.
Thanks.
Ms. Height. I guess there was a reference to you getting some supplemental information more recently and relaying that to counsel. I haven't heard that. I'm assuming both counsel have heard that or any other comments that you want to throw my way would be appreciated.
I can certainly provide that, Your Honor. I guess you've heard a lot from both sides today. I would just say a couple of things. One, having talked with both mom and dad and the girls, I would call your attention to page 5 of my report, where on line 8, I remark that rarely have I seen such universal improvement in all the parties of a case. From the time I first met and spoke with them, the level of tension was palpable all around, and it is reduced significantly all around now. One of the folks who spoke here a few minutes ago mentioned people have moved on, and definitely both mom and dad have moved on. The tension that was evident in their relationship has just it feels like it has melted away from both of them. What they have together now is that they both really clearly and dearly love these girls. My last conversation with the girls was relaxed and happy. They were they just seemed like they were doing really well in our conversations. They didn't seem stressed out when we talked about family issues. And so I stand by my report. I think it is time for everybody to move on, to go forward with a somewhat normal co-parenting schedule. And I think it is noteworthy that dad has demonstrated flexibility, and he spoke to me about being flexible as well, as if somebody wants to go home or if somebody wants to go to a friend's house or a birthday party, he was very congenial and understanding and reasonable about doing that. And I think that bodes well for them moving forward into more visitation, that it may take them a few weeks to get there fully, but I feel like it could happen and should happen. I think the girls are going to benefit by having a healthy relationship with both their mom and both their mom and their dad. The one thing that is clear is that both of these parents love these children, and these kids love their folks.
All right, I appreciate that. Thank you, Ms. Height.
Could I ask Ms. Height some questions?
Sure.
Because when I spoke with Ms. Height back on May 9th, she had indicated that she did not believe that it was appropriate for the girls to have extended residential time with Mr. Kaufman, that she was not aware of any vacation plans that he was having, that she was encouraged by both of the girls in their progress, but that she would not recommend more than 4 overnights at any one time. And I guess my question is that recommendation changed?
I don't really know how to answer that, Ms. McLean. I feel like it is reasonable to expect that they could go on a vacation trip of a week with their dad and have, or whatever they want to do for that week in the summer. So I feel like, given the modification of stress on everybody's behalf, I think that would be fine. The other thing that has happened is dad has gotten into a more stable housing. He was moving here and there, finding his landing spot, and he has now found that. And I think that has also helped to add some stability to the resolution of this case.
Okay, so, but I guess I'm just wondering what has occurred between May 9th when we talked, and you indicated that 2 weeks with dad would be too much time, and that no more than 4 days of extended time this summer.
Well, I think 2 weeks in a row is definitely too much. I think that they need to move into that. Where I see in practical terms is this: during the course of the summer, they will hopefully have moved into more time over the weekends. And as that grows, I think their comfort level is going to grow as well. And they could grow into a longer period than 3 or 4 days. So I think to say, the first week of summer, they should be on that, have that first week with dad, is probably more than they want to move into immediately. But I could see over the course of the summer, as things are more relaxed and plans are made and there's expectation of let's say a trip to the beach or somewhere, I could certainly see that would work out.
Okay. All right. And did you actually receive a copy of a domestic violence evaluation from Mr.
Yes,
Kaufman?
yes, I do have that.
So can you or counsel provide that to me, since I've not seen that?
Yes, I will get that to you.
Okay.
Let me make a note.
Do you have other questions, Ms. McLean?
Apparently not, no.
I would note that in that evaluation, it did say, I think I quoted it, it did say that no ongoing treatment was being recommended at that time, but I will get that to you.
Okay.
I'll come back to you, Ms. McLean. Ms. Baldwin, did you want to ask any questions of Ms. Height?
No, I think her report and her extra information that she's provided, I think are fine.
Okay, thank you. All right, Ms. McLean.
So just briefly, again, going back to Ms. Height's recommendations, her recommendation was first, third, and fifth weekends from Friday at 5 to Sunday at 7. The girls have been doing the first and third weekends, as I indicated, from Saturday, I believe at 10 a.m. To Sundays, I think at 5 p.m. To Sundays at 6 p.m. And if the court is inclined to provide for full weekends, we would ask that you transition to the first and third from Friday at 6 to Sunday at 6 to provide some consistencies as far as times go. If the court is inclined to provide some extended time for the father, again, in my discussion with Ms. Height, she was clear that she would not recommend more than 4 extended days, potentially 3 times this summer. We would propose that he be allowed at most to have the opportunity to extend to 3 weekends, 3 of his weekends, up to 4 days with at least 2 weeks notice to my client. We certainly don't want to have him have the ability to remove my client's weekends because she needs to be able to plan accordingly. I would also note that one of the recommendations is that Mr. Kaufman attend the girls' sports events and other activities, so long as his contact is appropriate. And he has still had minimal contact or participation in those events. Again, I think that that speaks volumes. If you go back to the declaration that my client filed in January, when the court basically called Mr. Kaufman out, you'll see that it was during the Christmas exchange that Mr. Kaufman is grabbing my client's butt and being verbally inappropriate to her in front of the girls. That was in December of 2022, not August or September. That was certainly after this event that occurred in November. Again, I think it's appropriate that we take this slow because we've got girls who have already balked when the court ordered that they go the Fridays to Mondays. Paige didn't even participate in those. That was information that Ms. Hyde took into consideration at the time. And again, her preliminary report back at that time, which was January 19th, so what is that, 4 months ago, had recommended that his visitation be reduced substantially because of the difficulties that the girls were experiencing. You've got teenagers here, or at least one teenager, one on the cusp of teenager. They probably both think that they're much older than they are, as most girls at that age, but they need to, if we're going to be healthy moving this forward, we need to move it at a pace that's appropriate for them, not forcing things that is going to make them balk, as we saw them do 5 months ago.
Your Honor, if I might just drop one more stone in the pond here.
Sure.
I do agree with the option that Ms. McLean talked about when we're talking about 2 weeks of summer vacation. I could also clearly see that if it is in the girls' best interest in this time, that they have 4 days, 3 times a summer. But I think that the option of having a week for them to take a longer trip would certainly be appropriate as well.
Okay, thank you. All right, so court's seen an evolution in this case. You know, I believe even some of the orders that were entered last year, I had a hand in. So I've seen this case more than just this year. I do want to say that I am extremely. I feel very much hopeful that these parties will eventually come to a good place where they can work together. I clearly think everybody is looking out for the best interests of the children, care for the children. Parties clearly were married and had these children and were together for a significant period of the kids' lives thus far. So I hope that they keep that in forefront. And it appears to me, based on the most recent guardian ad litem report, that they are doing that. And I appreciate that very much. We don't see that all the time. And I understand mom's pretty adamant about kind of limiting the time. And I don't know that I guess I'm not looking at it as cutting dad out, but more of wanting to protect the kids and kind of the transition through this. That being said, we are just past a year mark in this case. And I reviewed the GAL report. I've reviewed most everything that's been filed in this case. And I think I am going to expand visitation. Here's what I'm going to do. I'm going to allow for the 5th weekend. So 1st, 3rd, 5th weekend. I'm going to start that at Friday at 4 p.m. And I'm going to end that Sunday at 6 p.m.
Your Honor, may I just ask a quick question of my client, because I don't know what time she's off work and she works in Oregon. I just don't have that recall. I just need to know if she can make the kids available by 4 p.m. because right now the visitation exchange is on a Saturday, and previously was Friday at 6. So
she's saying yes.
4 p.m. is okay.
Okay. Thank you.
To Sunday at 6 p.m.
Okay.
So that'll be the 1st, 3rd, and 5th. So I'm going to expand
by
that.
Fridays.
Yes.
Okay.
And then I think Wednesday visitations are appropriate, and I think would be good. Obviously, these are active kids that are involved in a lot of different things, so that needs to be taken into consideration. So if there's a practice, a game, a club meeting, whatever it is, that's the priority. But I'm going to authorize the Wednesday visitation, and I'm assuming they're in a school with early release on Wednesdays. So after school Wednesday, and
Is that every Wednesday or are we doing the off week Wednesdays? I think previously we did the off week.
And I just ask it be it's easier for kids if it's every Wednesday. It's straightforward.
I'm gonna do every week. So from after school on Wednesday until I'm gonna say 7 p.m. Does that work for work schedules?
Yes.
Okay. I don't
Well,
want to,
if he's gonna have to pick up from school.
right.
Yeah.
I don't want them out too late. I would agree with the suggestion of, so my first thought as far as vacation, this summer, yes, he should have some. I was concerned about 2 weeks, even 1 week at a time, non-consecutive 2 weeks. My first thought was, well, let's wait until mid-July to see how things are going before we do that. I think a better option is to look at extending the weekends. That seems appropriate. If things are going well and the parties agree to a longer term, then I would obviously have no problem with that. But extending 3 different weekends for up to 4 days.
We're just asking for 2 weeks notice on that.
I think that's reasonable. So 2 weeks notice on that. And ideally for those to be attached to dad's already weekends. And if not, then maybe either more notice and mom would have to agree if it's not his weekend and work that out. But ideally that those would be attached to the weekends that he's already receiving.
The court saying ideally is, I think is the court saying this have to be part of his weekend, or can he select time?
I'm going to say, I get that. I'm going to say that they have to be his weekend. That doesn't preclude an agreement otherwise.
Okay.
As far as, I guess, are the parties in a position where 4th of July, Labor Day, Thanksgiving, Christmas, that can be sorted, or are you looking for me to make decisions on the individual holidays for the remainder of the year?
I guess my preference would be, I'd like to see how these extended visits go this summer, and either revisit that. I mean, I'm assuming that 3-day weekends that can occur or that occur, like what we're already through Memorial Day. So I guess we're talking about Labor Day. I don't know whose weekend that's scheduled to be. I think it would be a natural progression if we're going to do 4 days, 3 times a summer for him, that it would be appropriate to attach the 3-day weekend if that is on his weekend. And I'm assuming counsel and I are going to be on the cusp now as far as trying to talk, getting this case resolved. So before we jump into allocating like half of Christmas break or something, I'd like to see how the summer goes. And then if you want it, I guess maybe revisit it if we need to. We're going to have plenty of time to file a motion or to get it back on before your honor before Christmas.
And how wildly expensive for no reason. And if you look at the last parenting plan, we already apportioned all the holidays except for a few.
Oh, wait, can I interrupt you? Are you talking about the December one?
No, the March one.
March one? Okay.
Looking at March 30, 2023, the current active parenting plan apportions those holidays. So to say, now take them away and let's spend $2,500 per side to come back and relitigate. Why would we do that? That doesn't make any sense for what we're doing here. And it doesn't make any sense with what the guardian ad litem has said. The only things that need to be added back in are looks like some of the like Veterans Day, the one that falls on a Thursday, that's an odd liar, the 4th of July, and making it clear that school holidays are also days where any day where school's not in session. So those random in session days should create a 3-day holiday, but otherwise they're already set and we should just continue those, add in the handful that are missing and move forward.
I guess have been referring to the December plan more than the March plan, but I do see that winter break, all 3-day weekends not otherwise listed, Thanksgiving, Father's Day, Mother's Day, and spring break are already allocated. So I'm not hearing any reason to change that. I'll adopt that. I don't know if the parties want to, and obviously if there's concerns moving forward, that can be brought before the court. 1 and 2, part of the 4th of July, Veterans Day.
I don't think either of these folks have served in the military. I don't know why we'd be allocating Veterans Day unless it's a military.
Because it's a holiday. Because it often attaches a Thursday and a Friday, so it creates a 4-day weekend.
That's not true. It's on November 11th. November 11th rotates 1 day a year.
And when it falls on a Thursday, schools often take off that Friday as well. When it falls on a Monday, you have a 3-day weekend. So why wouldn't you?
Well, it looks like this year it's a Saturday. So that would assume that Friday would potentially be the observed day. I don't know what the court schedule is. Frankly,
court-
it doesn't often match the school schedule, so that probably doesn't help much. But usually if it's a Saturday, it's the day prior. If it's a Sunday, it's the day after. So if that's the case, then that potentially could be another 3-day weekend this year. So if the parties,
and my understanding is that it's only recognized on the day. It's not an additional day.
That's true.
I don't know if it's true. I don't even know if we have a holiday.
Well, we can address it on presentation. That's
Yeah,
I don't wanna get lost
If
in those.
there's an agreement to it, great. If there's not, then I will more than happy to
So otherwise,
to address that.
just so I understand, so you're adopting the holidays that were already in the amended parenting plan from March 30.
Yes.
But you're adding in 4th of July.
I'm sorry?
So my understanding was the court was adding in the 4th of July because that's not in there for
Yeah.
whatever.
The 4th of July and November 11th were the two that council pointed out that I can either decide now, I can decide at presentation and allow the parties to try to agree upon.
I'm happy to see if we can agree, and if not, we can just address it at presentation. They're just generally ones that rotate. We may disagree on the times. I think you can address that easily later.
All right. When would the parties like to set this for presentation?
I'm fine with next week if council's able to do that. I know your docket's full on the 13th and I'm out the 20th, and I don't want to wait till, or we could do it on Friday if that's better for council.
The only other issue is what about Mr. Kaufman, Dan Kaufman?
Thank you. So I knew there was something that I forgot here. I think from the GAL report, it appears that Dan Kaufman understands that it's ideal for dad to have time with kids without him being present. It sounds as though he's trying to remove himself from the situation. I would like that to continue. I'm not going to ban him outright from ever being anywhere near the children. I understand the concern. I understand, frankly, the growing pains of learning what it's going to be like to be in this new dynamic with kind of having two families now. If, however, I haven't heard any new concerns. So what I said prior still stands. If Dan Kaufman makes some comments that are at all concerning, please raise that issue, and I'm more than happy to consider that. I guess what I would like is for him to continue in his efforts to not be there when dad has kids. But if he happens to be there for some period of time, then no disparaging comments, and all of the bad actor standard language should apply to him as well.
So I guess just for purposes of drafting, because obviously we don't have jurisdiction over Dan Kaufman. So are we indicating that Justin Kaufman is encouraged to not have Dan Kaufman present during his residential time?
That would mean
or to limit?
It's challenging because he's still family. So this idea that we're creating an order that's kind of banning a party over statements we don't yet really have a real solid indication on.
How about the language just that Justin Kaufman is encouraged to have as much individualized parenting time with daughters as possible?
That's fine.
And I would hope that Justin Kaufman understands, that he's going to have to be the moderator of any of those situations in the best interest of his children. I don't have any reason to believe otherwise. So I would hope that would continue. However, if something should happen, then by all means that can be brought before the court.
Very good.
So as far as does presentation the 9th work? That's Friday at 8:45.
I believe that works for me.
Or I'm sorry, did we decide not the 6th?
Oh,
I'm happy with the 6th. That works for me. If you, I know council, you have the last order, so I assume you'll draft.
Yeah, I'll get them out by tomorrow.
That's fine.
okay. If the 6th works better, then we'll set this to July 6th June 6th at 1 o'clock for presentation.
Okay, thank you very much.
All right. Thank you all. I wish you the best of
Your
luck.
Honor. Happy birthday, Your Honor.
Thank you. All right. I believe that's it, Miss Wade. I think we can go off the record.